as I noted, this is not going to be an encyclopedic view of the Emergency Management Act, but will be a quick overview of some of the authorities that we've utilized over the course of the pandemic, and wanted to, basically kick off by looking at the core statute that we have for the Emergency Management Act, which is 166A of the North Carolina General Statutes. And the as you can see, the definition of an emergency is an occurrence or imminent threat of widespread or severe damage, injury or loss of life or property resulting from any natural or man-made, accidental, paramilitary, terrorism, weather-related, or public health. And the reason why I've highlighted public health is this was an addition to the Emergency Management Act and Session Law 2016-87. Based off of our experiences with other situations as far as prior pandemics, for example, the H1N1 in 2009, and other public health emergencies that had emerged in the interim, things like Ebola and other types of situations around the world. We felt that it was important to update the public health emergency law into the Emergency Management Act so there will be no ambiguity as it relates to public health emergencies. Of course, most public health law in North Carolina is in Chapter 130A, but this provision was added to the Emergency Management Act in addition to adding cyber incidences, making it clear chemical other hazardous material incidences were also added to the definition of emergency, such that whenever the governor or local government needed to deal with the situation, the Emergency Management Act had no ambiguity as far as the types of all hazards that the emergency management field has to when we approach events. That was also recognized in our general statute. Another feature of the Emergency Management Act is defining the emergency area. And the Emergency Management Act was first enacted in 1979 as an outgrowth of the old civil defense laws from the 50s and 60s during the Cold War. And the Emergency Management Act was modernized in 2012 to where, with the new Article 1A, where most of these authorities reside now in our statutes. So that was one of the important additions that we added to it was the defining the emergency area, which is a geographical area that is covered by the state of emergency. And then another feature that was made to the Emergency Management Act was clearly delineating what is a disaster declaration, because prior to the 2012 update, most of the emergency laws were in Chapter 14 under the riot and civil disturbance statute. So whenever in Chapter 166A only had disasters, a state of disaster as a defined term in the Emergency Management Act. So with the modernization of that, we pulled all those old civil defense statutes that were in criminal statutes in Chapter 14, including the definition of emergency, into Chapter 166A to be able to, again, have a comprehensive Emergency Management Act law in North Carolina that was housed in one place in the general statutes. Now, there are some provisions that are still in Chapter 14 as it relates to the penalties and punishments for violating a state of emergency, but, and I'll get to those in our presentation, but I wanted to really highlight the historical evolution of the Emergency Management Act as it has come into being in present day. So one of the key features of the Emergency Management Act is the powers of the governor. Of course, the state emergency management program for the state includes all aspects of preparing for, responding to, recovering from, and mitigation against both wartime and peacetime emergencies. And so the powers, the governor is basically the lead person in our state as to monitor and exercise general direction and control over the state emergency management program. And then, of course, the governor can then delegate those powers to other individuals. And also, if it's powers that have been conferred directly and exclusively on local governments, they control the local government space. But I'll show in the presentation here today how both the state and local emergency management laws interplay when dealing with the COVID-19 pandemic. Two provisions here in 166A-19.10 that have been very critical to any emergency, and in particular during the COVID-19 pandemic, is numbers 2, 3, and now also 4 with some of the with, for example, the mass vaccination center that is being stood up in Greensboro, where our federal partner is working with FEMA. But number 2 is, of course, anytime there's a state of emergency, the governor has the authority to make any orders and rules, regulations to deal with the event. And also, as I noted, number 3, the governor can delegate any of that authority vested in him or her under the article and provide to the sub-delegation of authority there to others as well. So that has come into play pretty frequently here during the COVID-19 pandemic. Where do you find the actual statute that gives the governor authority to declare a state of emergency? And that's in 166A-19.20. It gives the governor the authority to, again, declare by executive order, as mentioned in 19.10, or the General Assembly can also declare a state of emergency by passing a resolution if either party finds that an emergency exists. Within that executive order or that resolution that will declare a state of emergency, you will have a defined emergency area. And again, that's defined by statute. That could be anywhere in the geographical area where the emergency exists. And so, for example, with the COVID-19 pandemic, clearly the entire state of North Carolina was declared as the emergency area. But there's been situations where the emergency area could be very small. To give you an example of that, we just recently had a tornado that hit down in the southeastern part of the state in Brunswick County. And in order to help with the recovery efforts from that particular event, the governor declared a state of emergency just for Brunswick County to deal with the impacts from that tornado. So again, the emergency area can be very broad or it can be very narrow. Whenever the emergency period has passed, another document has to be issued to formally rescind the state of emergency in the area where it was declared. So many times, once we've been through an event, of course, the COVID-19 pandemic is still ongoing, so that declaration has now been in place coming up on a year on March 10th. But other events may be very limited duration. For example, the winter storm that we had just a couple weeks ago, we declared a state of emergency to help with power restoration. And then, of course, we just issued the executive order standing down that event last week. And then one other feature is a state of emergency, once it's been declared, really once it's been declared, the fact that a disaster declaration has not been issued does not impact the state of emergency at all. So I'll get into disaster declarations later, but that's essentially at the state level, either the governor or the legislature can declare, and then at the local level, under 166A-19.22, a municipal or county government may also declare a state of emergency in their jurisdiction wherever the event happens. So with the local government interplay, many times you'll find that, and particularly in the COVID-19 pandemic, local governments have issued both municipal states of emergency, and also the whole county has issued a state of emergency. And one of the interesting features about the municipal laws is, again, since it's only in the geographic area where it has where the particular emergencies happen. During the COVID-19 pandemic, counties and city governments have worked together to for cities to pass resolutions asking the county to declare a state of emergency for the whole county and also include their jurisdiction within it. So we found many situations where to avoid any conflicts between what may be in the county geographic area, but within the corporate municipal limits of a city, you may have had different restrictions and stuff. So to make sure that there was no conflict between the two, many local governments work together to pass a unified state of emergency for their jurisdiction. Just have a little fun with the office here. A little creative liberty with Michael Scott there. All right, so once we get past the initial threshold of a declaration of a state of emergency, what are the additional powers that the governor has to deal with the event in order to basically bring things back to as close to normal as possible? So a component of any of these executive orders, and if you've had a chance to look at them, you'll probably see this provision in many of them, which is 19.30A1, which is to utilize all state resources as reasonably necessary to cope with an emergency, including the transfer or direction of personnel and functions of state agencies. So that has been done, quite frankly, in every just about every executive order, because again, this is all hands on deck approach to dealing with the COVID-19 pandemic. So the governor has, for example, used his authority to make sure that HHS can take on various public health or emergency response, and also to plus up any state resources to help deal with any hospitalizations and testing, and now vaccination as well to deal with the COVID-19 pandemic. And then the second provision, which is the enforceability of these executive orders, where the governor will give action and directions to state and local law enforcement officers as reasonable and necessary to secure compliance with the executive order. And of course, throughout the pandemic, that has definitely been where we have utilized both local law enforcement to help enforce various provisions of the EOs that have been issued by the governor, as well as state agencies such as the Alcohol Law Enforcement Division, who has helped to enforce the alcohol curfews that have been issued in executive orders since this past summer. One component that has been, you've probably seen quite a bit in the news, especially last summer when the pandemic was and is still relatively early to mid stages, is the issue of counsel of state concurrence. And so during a state of emergency, there are certain actions that are taken by the governor that he or she can do on their own, but then there are other things that require the council of state to concur in their action. So I've highlighted several of these that have been utilized throughout the pandemic, one of which is to direct the compel the evacuation of populations. Of course, that primarily has come up with hurricanes, and for example, with hurricanes Florence and Dorian, Governor Cooper issued executive orders to compel the evacuation of the barrier islands, and so that one's one of the clear ones that's utilized there. But also to prescribe modes of transportation and destinations, and control ingress and egress out of an emergency area. Again, those are utilized to help with any type of storm recovery efforts. And also, for example, with winter storms, we will utilize this provision to help get power trucks into emergency areas to help quickly get the power restored. Another one, B2, is one that has been utilized quite frequently during the pandemic in particular with the utility and rent moratoriums that were issued early on during the pandemic. In particular, of course, the Chief Justice had issued their moratorium, and then the governor and the attorney then also did a belt and suspender approach with an additional moratorium to utilize this provision in the executive order, at least with the first eviction moratorium that we had during the pandemic. A second one that I'll touch on later utilized a moratorium that was issued by the Centers for Disease Control. But B2 was the one that we utilized to do the first moratorium and also to help with utility shutoffs in the early parts of the pandemic. B3 is another one that's, again, utilized frequently to help move materials and resources quickly to the emergency area, where there's power restoration, commodities, in the pandemic support as far as testing materials and now vaccination. And then number 4 and 5 have also been utilized to help, in particular, with various regulations that may have been put into place by state agencies that were relaxed to basically help plus up any public health or any type of support for the Department of Health and Human Services to deal with the pandemic in order to make sure that people could get, we had adequate medical resources and other items to deal with the pandemic. And then number 5, exercise and perform other functions that's necessary to promote and secure the safety of the population. An example of that executive order has been the stay-at-home orders, but also, well, actually not the stay-at-home orders, but the school closure order that was issued almost a year ago when the state recommended and ordered, working with the State Board of Education, the closure of schools to deal with the pandemic. Additional powers that also come up is the 19.30C powers. And this one is a very critical one under the Emergency Management Act, in that whereas under 19.30B, it requires concurrence of the Council of State to do certain relaxing of rules and regulations to deal with an emergency, 19.30C gives the governor the ability to move forward if the governor determines that local control of an emergency is insufficient to assure adequate protection for lives and property. Now, this, with the 19.30C, it does not have to go to the Council of State for concurrence, which was, and in the past, this particular provision was used, for example, in 2016 for civil disturbance that occurred in Charlotte after police shooting. But here in the COVID-19 pandemic, this has been the legal basis that the governor has utilized to execute all the various stay-at-home orders and all the and subsequent phases 1, 2, 3, and the modified stay-at-home orders to deal with basically do the various shutdowns and restrictions for dealing with the pandemic. So in order to utilize the statute, 4 factors have to be evaluated. 1, you have to look to see if needed control cannot be imposed locally because the local authorities responsible for the preservation of peace have not enacted appropriate ordinances or issued appropriate declarations. So whenever the first stay-at-home order went into place, this is one of the things we were looking at, and we actually did survey the state to see who had issued any local stay-at-home orders and who had not. And so, of course, there was becoming a patchwork across the state. Then you go to the second step, you see if those ordinances have been declared or have not taken steps to implement those controls. Basically, if then that would be another factor for the governor to move on their own authority to exercise the 19.30C powers. And then, of course, the area in which the emergency exists is spread across local boundaries, and legal control of the measures of the jurisdictions are conflicting or uncoordinated to the extent that efforts to protect life and property or unquestionably will be severely hampered. And that clearly was an example of what was happening during the early part of the pandemic with the various stay-at-home orders. Again, you were having conflicting orders, even to the extent within counties, as I noted before, where maybe Durham County had certain levels of restrictions, but the city of Durham had other types of restrictions. So in order to level the playing field, which gets to number 4, the scale of the emergency is so great that it exceeds the capability of local authorities to cope with it. Clearly, the COVID-19 pandemic fell into that category because clearly this was an international event. And so looking at all those 4 factors, the governor then utilized this statute to execute the very first stay-at-home order. And so once the governor has done that, it also opens the door to allow the governor to crosswalk over to 19.31B, which is where primarily local governments, and I'll touch on that statute here in a moment, have various authorities, very similar to what you see what the governor can do via the Council of State concurrence authorities. But now, given that the governor has moved on their own motion to utilize the 19.30 powers, they can then crosswalk over to the 19.31 powers and can amend or rescind any prohibitions that local governments have enacted. And then prohibitions and restrictions imposed shall take accordance with the provision in effect, like the provisions in 19.31. So basically, to give an example of that, many local governments had enacted measures to deal with retail. And in order to keep from having a patchwork of retail rules that may be different, say in Wilmington versus in Asheville, the governor preempted the field as far as the retail rules. So utilizing the 19.30 powers, the state had one uniform standard as far as what the retail rules were going to be as far as capacity limits and occupancy limits at their sites. But the governor did not preempt the ability for local governments to enact stricter stay-at-home ordinances if the situation within their county or city was worse than other parts of the state. So even though there was preemption on one level of the retail, locality still had the authority and ability to enact more stringent COVID-19 responses because at some points the pandemic may have been worse, say in Charlotte, than it was, say, than in Boone or somewhere else in the state. So, but when the governor did issue the stay-at-home order, we did have just a baseline. Everybody has to follow these essential rules, but then with the exception of retail, everything else, if the local government wanted to add more to it, they had the ability to do so. And then 19.30C2 gives, again, the governor the ability to basically appoint an incident commander to deal with a situation to basically carry out the duties and restrictions or authority that the governor is utilizing to deal with the emergency and the executive order. And that one, C2 primarily comes up in the past, it's come up in the context of riots and civil disturbances. As I noted earlier, 19.31 gives the localities, municipalities, and counties to enact ordinances to deal with the emergency. And again, this is where we did the crosswalk into 19.31B, where the governor was able to utilize these provisions to do various types of restrictions under the stay-at-home orders, and also later in the pandemic, the alcohol curfews as well that have been that were first enacted during phase 2 back in the summer when there was a concern about establishments, particular restaurants, as things were starting to restrictions were starting to lessen. Too many people congregating in sites that, in the view of the public health authorities, was detrimental to the public health. So, utilizing the B1 provisions, this is where you can impose the curfew, and also can also deal with, we utilize B1 to do the initial stay-at-home orders. So that's how the governor was able to restrict individuals when we had the initial phase stay-at-home order, and then and including the phase 1 stay-at-home order as well. And then these authorities can also again provide for the ingress and egress out of areas. So utilizing any of these provisions in B, like congregation offices, establishments, again, that's utilize that for some of the curfews that have been put into place. B3, this gets into the alcohol curfews that have been issued since phase 2, and then also other activities, the real catch-all, the other activities or conditions that may be reasonably necessary to maintain an order and protect lives during a state of emergency. So again, 19.31 crosswalk from 19.30 are very, very powerful statutes that the governor can use to deal with an emergency. And as long as those 4 conditions in 19.30 C1 have been met. As far as local governments, again, 19.31C gets into when they can enact ordinances on top to deal with emergencies. Of course, many local governments have their general police power to deal with situations, but on top of that, whenever the local government may have declared a state of emergency in their jurisdiction, this gives them the authority to enact additional ordinances to deal with the situation at hand. And many local governments avail themselves of this authority during the COVID-19 pandemic to do those additional restrictions. Those restrictions take effect as soon as the ordinances have been adopted and publicized, unless the declaration says that they'll occur at a later time. And then, of course, those they expire when it's either terminated by the official who has imposed the restriction, or the state of emergency itself terminates. And as I noted before, this provision is primarily there to supplement other authorities that local governments already have under their general police powers. And so, this again just reflects that whenever you have emergency, sometimes you'll have to take additional steps that may have not been contemplated earlier when ordinances have been established. So violations of executive orders or local government ordinances, as I noted before, have been mentioned both in the Emergency Management Act, and then also you still have in Chapter 14 the criminal sanction as well. So if you violate an executive order that's been issued by the governor, it's a Class 2 misdemeanor, and it's penalized in accordance with Chapter 14-288.20A. If you violate a local ordinance, it is also a Class 2 misdemeanor. And so both of which are punishable by 1 to 60 days in jail, depending on the prior criminal history, and $1,000 fine. And speaking of violations, this is of the executive orders. There's been much with the mask mandate. There's been an evolution of that throughout the pandemic. In particular, with the mask mandate, whenever the which I think probably is the main one that gets people's attention. It was originally not enforced by law enforcement. However, if a business wanted to, if a person came onto their business into a business site and failed and did not wear a mask, and the business owner asked them to leave, and the person did not do so, then originally the violation would have been through criminal trespass. However, as the pandemic evolved, and in particular in the fall when there was concern with the various holiday surges after the summer surge, the governor tweaked that provision that, again, in addition to the criminal trespass, law enforcement could also enforce the mask mandate as well, and as well as local governments could as well. And given that many local governments were reticent to sometimes, or local law enforcement were reticent to cite someone criminally, there was direction given to local governments with some examples of how you could use civil violations so that people could, so that local law enforcement could also be encouraged to utilize civil violations as far as fines to be able to get into encourage compliance with the executive order. And of course, that did create some issues. There was some discussion with the School of Government about whether or not local governments had that authority or not. But state DOJ did opine that that was an authority that local governments could utilize to help enforce the executive order. I wanted to also touch on the liability protections, both under state and federal law, that are at play with the COVID-19 pandemic. Many of you may have heard of the PrEP Act, which is the Public Readiness and Emergency Preparedness Act. And it was enacted by Congress in 2005. And whenever the initial, it's been utilized several times before, even prior to the COVID-19 pandemic. And basically, it gives immunity from tort liability from claims except for willful misconduct to individuals involved in the manufacture, distribution, and dispensing of medical countermeasures. And the reason why I bring that up now is, of course, prior to this, the declaration was issued early on during the pandemic, and it was really focused on, of course, at that time, on the testing materials and things that were, and medicines that were being given to people to try to help them deal with the virus. But of course, it's been amended several times and have included vaccines and vaccine providers. And so with this, it shows where you can have various protections under the act, and it extends to individuals, partnerships, and corporations and others who are helping with any countermeasure. So this is a federal law that is very complicated and has lots of little, like any law, has lots of nuances and tweaks to it. But I definitely wanted to share that with you today, because that is something I'm sure that is top of mind of many organizations, in particular any organizations that may be helping to volunteer with any vaccination efforts going on in their community. The question of liability has, at least in my experience dealing with this, has come up more now than it did since the beginning of the pandemic, when people were concerned about medical surge whenever the pandemic first happened. In addition, in Session Law 2002, 20-3, there was also state law that was put into place when that act passed in May of last year. And again, to provide an additional state liability protection under the Chapter 90 laws under the Emergency or Disaster Treatment Protection Act. And again, it tries to help mirror federal law so that, because with the PREP Act, there is a preemption clause within the PREP Act if state law is contrary to the federal. But this one tried to mirror federal law to address these the public health issues that were going on at the time, and of course the liability concerns that at that point was dealing with medical surge. But now, as I noted, we're into the vaccine distribution, so that is another thing that is up top of mind of individuals. So when you go through it, of course, it gives the various, this applies to COVID. It references the governor's executive order, any rule. It includes executive orders, declarations, directives, or of any state or federal authorization. It gives, of course, defines damages, defines the healthcare facility, as I noted before. The concern at that time when this was passed was dealing with medical surge, but now also, of course, healthcare providers and healthcare service as well. And of course, you see, in particular for nonprofits, any medical organization, company, institution that's made its facility or facilities available to support the state's response and activities under the COVID-19 emergency declaration. And so many entities have shared their facilities. For example, the Four Seasons Mall in Greensboro for the FEMA mass vaccination event that will start next week is an example of that. And then other volunteer organizations that may have stood up clinics in their communities. So I wanted to, again, share that state liability protection in addition to the federal one. And here's some additional ones. And of course, again, of course, the severability clause, and then the when the act applies for this particular event. And then last, as far as liability protections, the Emergency Management Act also has general liability, limited liability protection as well for emergency management functions. And so any emergency management function has been deemed to be a governmental function, and basically persons are immune from liability unless it's willful misconduct, gross negligence, or bad faith. And of course, the immunity also flows to other individuals who, as far as firms, partnerships, associations that may help with dealing with the emergency response. But of course, with that, the immunity only applies under certain conditions. One, if those entities are helping at the direction and control of state or local, or at the request of state and local governments. And also, there is some waiver language in there as well if those corporations or entities have liability insurance, the immunity protections are waived up to that point of insurance. In addition to the liability protections under that section, of course, it deals with the worker comp issues, license requirements also could be suspended. And this comes into play in particular when we utilize resources from other states through the Emergency Management Assistance Compact. Many times, if you're licensed professionals coming in to help with a situation, this statute helps to deal with those particular issues in addition to dealing with mutual aid agreements. And then Section E defines an emergency management worker. And as you can see, it's pretty expansive as far as any full paid volunteer or auxiliary employee of the state or other states, again, get into the mutual aid context, or the federal government. And the critical thing is when these people are engaged in this emergency management activity, they are doing it subject to the order, order of or pursuant to the request of the state government or political subdivision when performing that emergency management function. So again, this is additional liability protections that individuals have when dealing with an emergency in their jurisdiction. And then one other one I didn't add into the PowerPoint here, but there's also 166A-19.31, which also provides liability protections for private entities that allow for their real or personal property to be utilized to deal with an emergency if it's done at the direction and control of the state or local government or political subdivision thereof. So that's another liability protection, so that if a person allows you to use their facility to host a shelter, or in the COVID-19 context, a vaccination site, that's an additional protection that you have. So as you can see, there's multiple levels of protection from federal on down to state law to deal with the pandemic. So last, I wanted to go over the various types of declarations for disaster. Under our Emergency Management Act, it's found in two basic places, in 166A-19.21 and 166A-19.41, that gets into the funding aspects of assistance. But whenever the governor declares an area, or the General Assembly, whenever the emergency happens, rises to the level where there may need to be a need of a disaster declaration, the first step that is done is a preliminary damage assessment. And the Secretary of my agency, Public Safety, will provide the governor and General Assembly with the preliminary damage assessment. And then if once that has been found, if it meets the criteria, the governor will then declare the area a disaster and classify it as a type 1, 2, or 3 type of disaster. So under the type 1 disaster, which is typically a state level event, is bad, but it doesn't rise to the level of where the federal government will come in, because the event has been such a magnitude and severity that it has exceeded our state's ability to respond. Our state will then utilize the type 1 disaster. And so for individual assistance, which I'm sure many of you are familiar with in your work, maybe helping storm survivors, some of the most recent ones that we've had have been the Alexander County earthquake that happened back in the summer. The state will provide individual assistance, and the programs that we have at the state level mirror many other programs that are available at the federal level as well. So you'll have rental assistance, replacement of personal property, and other will also provide the first year of flood insurance as well if it's a flooding event and doesn't meet criteria for possible FEMA declaration. So that's the types of things under the individual assistance program. We also have a public assistance program under our state disaster response program. And again, it mirrors the FEMA program, but it doesn't have as many categories of response tools that the FEMA program has. But local governments can get reimbursed for debris clearance, any emergency protective measures, roads and bridges that may have been lost. Crisis counseling is also covered as well, and any assistance with public transportation needs. So those are some of the state programs that can reimburse local governments with costs associated with events, and those are we've done those pretty frequently as well. There's been flooding events in McDowell County, for example, that have been declared public assistance disasters to help those local governments recoup the cost of responding to those events. These disaster declarations expire 60 days after issuance and can be renewed by the governor or the General Assembly in 30-day increments. The second type of disaster declaration could be a type 2. And this is one where the event is your larger types of events, thinking like a Hurricane Dorian or where the COVID-19 pandemic. The governor can request federal assistance because the key language in the Robert T. Stafford Act is that the event has exceeded the state's ability to respond to the event. And so the governor can make that without having to do an executive order declaring a type 2 declaration. But this is your typical types of gubernatorial declarations of disaster that you see. And of course, the FEMA declaration comes with it under the Stafford Act. And in addition to the federal assistance, there are two types of state programs that are also a part of that as well: our state acquisition and relocation funds, and then also supplemental repair housing grants also. And this type of declaration can be in place for 12 months unless it's renewed by the governor or General Assembly, and can be renewed in increments of 3 months each, but not to exceed 24 total months. And then the last type of disaster is a type 3, which again, it's your major type of events, thinking Hurricane Florence or Hurricane Matthew, and also Floyd back in as well. This is the situation where, yes, a federal declaration has been declared, and the PDA, the damage assessment, shows that it's going to meet the threshold for an increased federal share of disaster assistance, meaning like a really massive event. And that event prompts the PDA prompts the governor to call a special session of the General Assembly to set up programs to deal with unmet needs that aren't met by our traditional disaster programs. And again, most recently, we've seen that with Hurricane Florence in recent memory. And so the types of assistance, again, you have the SARF funds, the supplemental repair funds, and then the third thing that's added to this is any programs authorized by the General Assembly, which of course, you've seen that in the various disaster recovery acts of 2016, 2017, 2018, and the Florence Disaster Recovery Act as well. And they expire, this type of declaration expires 24 months after its issuance, unless renewed by the General Assembly. So as I noted, those are the state programs. There are federal programs, two programs that are primary that come into play, and in particular have come into play during the COVID-19 pandemic, has been the Small Business Administration Disaster Loans Assistance Program, and they have provided economic injury loss loans to individuals impacted by COVID-19. And then, of course, the Robert T. Stafford Act, where there's two basic programs under that. The Major Disaster Declaration Program, which was declared a major disaster upon the governor's request to former President Trump. And this is COVID-19 is very unique in that for the first time ever, all 50 states and U.S. territories were declared major disaster under the Stafford Act. And then also there's the Emergency Declaration Program as well under Section 501B of the Stafford Act. And that's typically done in pre-COVID-19 days. You will see that done with hurricanes. And also another recent example of that that we've seen in the news was the situation with the power losses in Texas a few weeks ago when they had their crippling winter storm there. And of course, after that emergency declaration, in most cases, a major disaster declaration will follow from that. But the statutory language for major disaster declaration, interestingly enough, does not cover pandemics, but USDOJ opined that that Stafford Act could also cover this event as well, given the nature of COVID-19. And as I noted before, the key buzz terms whenever the governor makes the request to the president for this declaration is the event exceeds the capabilities to respond. And another note about the Stafford Act is, in addition to the governor, Native American tribes also have the ability to make a request to the president for a major disaster declaration as well. And that was a change that was made after Hurricane Sandy. And just a little local historical note, the Eastern Band of the Cherokee was the first Native American tribe, federally recognized Native American tribe that took advantage of that change after the Stafford Act amendment after Hurricane Sandy. Some of the examples that have been used during COVID-19 to help with under the federal disaster declaration has been the crisis counseling. That was a program that we requested assistance from the federal government to deal with COVID-19. And then also back in the late summer, early fall, the lost wage program, when the president authorized the FEMA administrator to provide supplemental lost wages to people receiving unemployment assistance, because Congress failed to extend the provisions from the earlier COVID relief bills that they had passed in 2020. Again, just real quick, the types of programs that are available under the federal programs. Again, as far as emergency declaration, the debris removal, emergency protective measures, and then you see the various types of programs that are available. Typically, these programs are done at 75% federal, 25% state as far as the cost share. But President Biden recently issued a memorandum that all the major the public assistance programs under the Stafford Act is going to be covered 100% federal. So that's a big plus for our state and all states to deal with the COVID-19 pandemic. I've provided to you a list of all the executive orders, and you can go to this link here to get all the orders that have been issued. And I've touched on many of these orders throughout my presentation this morning. One that was noticed this afternoon, one that was notable that when you look at the list, there's also an executive order for nonprofit and also for shareholder organizations to be able to be able to meet throughout the pandemic because did not want to violate various provisions of the business laws in our state. So that executive order again showed the flexibility of the emergency powers, gave the ability for those entities, and has been extended multiple times. Just recently, February 28th, to be able to continue that meeting flexibility. And again, you can find that in the link that's provided here. And so with that, I'll take any questions.